Once you've gone through the entire personal jurisdiction test, that is, you determine there are minimum contacts and personal availment, you've done the fairness balancing and decided that it doesn't upset personal jurisdiction, or even if it does, there's presence, domicile, or consent, the long-arm statute allows jurisdiction and venue is proper, we're still not done. And by the way, the fact that the process is so long is a very good reason for your professor to make a question like this on the exam. It gives you a lot to talk about. Make sure you're prepared to do so. Sometimes after all of those steps are applied, it's just terribly inconvenient to hold the proceedings in a particular location. Take a look at 28 U.S.C. 1404A. It gives the court's power to transfer a case to another court in the interests of convenience. Now make sure you understand clearly the difference between convenience and venue. If venue is improper, the court, as a statutory matter, may not hear the dispute unless the defendant waives venue. Convenience is different. Convenience says that even if the court can hear the dispute, it shouldn't, as a matter of again, statutory law, but it's not banned from doing so. It has jurisdiction. It has the authority to transfer the case to another one if it wants to. Now, if the only convenient court is a foreign court, much like we spoke about a minute ago, if venue only relies on a foreign court that is out of the United States, courts have a common law power to simply dismiss the lawsuit altogether, and probably will in that instance. It won't transfer the suit to another district that can't hear the dispute either. It's going to dismiss the case and instruct the plaintiff, or at least hope the plaintiff, will file his lawsuit in the foreign court. Transfer under Section 1404A is available only if the transferee court, that is the one receiving jurisdiction, is the one in which the action could have been brought in the first place. That means that the transferee court must have subject matter jurisdiction, which we're going to discuss momentarily, and personal jurisdiction, without regard to the defendant's consent. By hypothesis, the defendant wants transfer. The defendant's consent to the jurisdiction in the new location doesn't matter, and it must be a proper venue, again, without regard to the defendant's consent. So how do the courts determine whether a forum is inconvenient? And here again, we have another balancing test. Number one, you look to the convenience of the parties. Where is it more convenient to hold this litigation? But you look not just to the place of residence here. Remember, this is an equity we're talking now. You also look to the relative financial means of the individual parties. If traveling 50 miles for one party is going to be extraordinarily difficult, we're going to try to move the case closer to that party than the other one, just as a matter of convenience. Keep in mind that convenience to the counsel is basically irrelevant. You don't count, sorry. It's only the parties. Number two, convenience to the witnesses. This is probably the single most important factor. It just does not seem fair to force the witnesses, who again have nothing at stake in this litigation, to fly across the country to provide witness in a particular dispute. Number three, and relatedly, whether we can compel the witnesses to come to the trial at this particular location. If we can, we would rather not, obviously, but if we can, it makes it a lot easier for us to hold the trial in this location. If we can't force the witnesses to travel across country, well, that counsels very heavily in favor of transfer, because we want the witnesses to be able to testify. Number four, basically a catch-all, the interests of justice. If something doesn't fit into this list, use the interests of justice to affect convenience and your convenience analysis in this trial. Number eight, we've spoken about a couple times already, and that's judicial efficiency. We don't want redundancy in the legal system. Courts cost a lot of money. Judges command a big salary. Paying witnesses and forcing witnesses and jurors as well to leave their place of work and what it is that they have to do and come to the court to testify or to hear the trial is tremendously inconvenient for all of those people. It's a big use of time. We don't want duplicity in litigation, and so judicial efficiency is going to be a big factor. We're going to try to consolidate cases rather than separate them wherever we can.